Hey, good afternoon, everyone. My name is Jeff Burkhardt. I'm the Executive Director of the Texas Indigent Defense Commission. We are very excited that you're here today. This is a joint webinar series between TCDLA and TIDC. We are very excited to partner with our friends at TCDLA again. If you've not seen any of the past ones, we'll get to a slide in a second to give you a link to that. But before we get there, we love Julie and we love Jordan. They are both very bright, and neither TCDLA nor TIDC is basically endorsing anything that they have to say today. They're very kind to join us today and offer their thoughts on things, but anything they say, which I'm sure will be brilliant, despite that, please don't take it as an endorsement from TCDLA or TIDC. If you go to the next slide, so if you haven't seen the past webinars, there's a link to them right here. You can see we had, and this first one, gosh, I really urge you all to check it out if you haven't. Our own Kathleen Casey Gomez did the first one about online courts for defense attorneys. This is absolutely where you should start. This is, if you've never used Zoom or if you've only used Zoom for conference calls, you have not used it for online courts, this is a great place to start. Kathleen really goes through all that kind of the details and breakout rooms and virtual backgrounds and all the things that you need to know for Zoom and online courts. The week after that, we had Professor Jennifer Lauren from the University of Texas talking about online courts and the law. The following week, we had the head of the Office of Court Administration, David Slayton, as well as the Chief Public Defender for Far West Texas, James McDermott, talking about what life is kind of like for early adopters and some of the things that they've learned. And then last week, we had Grant Shiner, who is the incoming president of TCDLA, and Grant talked about tools you need for working virtually in the new age of online courts. So he was fantastic. All of those things you can see the link here. Kathleen, if you're kind enough to maybe put that same Vimeo link in the chat box, so we'll have it there for you all as well. So those are the past webinars. And Julie, if you can go to the next slide. We have some upcoming webinars too. So next week, Kathleen Casey Gomez is going to join us again. We also will have Casey Kennedy. And Casey is the head of IT for the Office of Court Administration. They're going to talk about, we're basically going to be one month in, believe it or not, to online courts starting next week. And we have learned a lot in that 1 month. And so Kathleen and Casey will be going through a bunch of that next week. The week after that, we have another UT professor. We have Chris Roberts. He was a professor, or is a professor at University of Texas. He was also an attorney with the Public Defender Service in DC. He practices now as a clinical professor here in Texas. He's going to talk about client-centered representation in the age of COVID-19. So that'll be the following week, May 7th. That may wrap up the series. If you all have anything really pressing that you'd like to hear about before we wrap up the webinar series, please put it in the chat box. We'd love to hear about that. And as I mentioned at the beginning, if you have questions for either Julie or Jordan, please just go ahead and put those in the Q&A and we'll get to as many questions as we can. And I think that's it. Kathleen, can you think of anything else before we hand it over to Julie and Jordan?
No, I think that's great. I went ahead and put the link to all our previous webinars in the chat box.
All right, thanks, Kathleen. All right, well, Julie and Jordan, please take it away.
Okay, so I'm actually gonna start for y'all today and then I'm gonna pass it over to Julie. Thank you so much for being here, and obviously a huge shout out to all the defense attorneys representing clients in these completely insane times. I feel really privileged to work with a lot of you, and these are really difficult times for your client, and I think they're difficult times for attorneys personally. And so just wanted at the outset to say, hopefully this is helpful, and if there's any way that Julie and I can support the important work that you guys are doing, we really want to do that. So, okay, so I'm going to dive in. So today we're going to talk first about what Padilla requires. Then we're going to talk a little bit about COVID-19 and how to sort of comply with Padilla under these unusual circumstances that we're in, and how to support your clients, your immigrant clients in particular in this time. And then I'm going to pass it over to Julie, and she's going to talk about her amazing work that she does with myPadilla and why you really want to have a Padilla resource. So those are sort of the big topics we're going to cover today. And yeah, I guess I'll dive right in. Okay. So first we're going to talk about what Padilla requires, and I'm sure a lot of you are familiar with the decision, and you're probably wondering why we're talking about it again, but the reason is there's a lot of chaos right now in the immigrant community and obviously with clients in custody. And I think it's important to remember our constitutional obligations under Padilla, despite all the other chaos that's happening. So we're going to sort of start from the beginning and look at the requirements of Padilla again, and then we'll talk more specifically about COVID-19's impact. So as many of you know, in 2010, the Supreme Court came down with this pretty radical decision, as it were, that really changed the scope of defense representation because it added a very new large obligation for defense attorneys, which was that defense attorneys need to advise non-citizen defendants about the immigration consequences of the charges against them and any plea. So why did the Supreme Court do this? This is obviously, as a defense attorney, this was a huge bomb dropped in their laps. And I think you really have to look at the historical backdrop to Padilla to understand why this happened. And if you see the quote that's up on the right, basically the immigration laws changed radically in 1996. So radically that the Supreme Court, I think, sort of was backed into a corner, where previously there was a whole bunch of discretionary relief that you could seek, and immigration judges could weigh criminal offenses against good deeds or family ties. In 1996, when the immigration codes were rewritten, they had all these mandatory bars, things that basically resulted in deportation no matter what you did. So I think against that backdrop of these very, very harsh changes in immigration law that basically tied a state criminal conviction almost entirely to the outcome in immigration court, sort of fusing these systems and the rise of what we call the crimmigration system. I think that historical change is really why the decision came out the way that it did. And also, I think the court was looking at the somewhat disproportionate outcomes that started to happen, where someone would plead to something that seemed minor in state court and all of a sudden would have these sort of radical consequences on the immigration side. So they were looking at the historical backdrop, they were looking at this proportionality issue. And I think sort of the third piece of this is that defense attorneys were the last attorneys standing, the last attorneys in the room, right? Like the Supreme Court is recognizing that the situation has gotten very difficult for non-citizen defendants. And really the only person left who can address it is the defense attorney. And so, you know, the facts of Mr. Padilla's case, I think, really speak to all of these issues, right? He'd been a green card holder for like 30 years. He's a Vietnam War veteran, and he was arrested on a drug charge. And his defense attorney in Kentucky told him, don't worry, you're a veteran. You've been here a million years. You can't be deported, which under the immigration law was totally inaccurate. So he pleads and is subject to basically mandatory deportation. And so I think, you know, his personal case is a real illustration of the sort of changing environment for non-citizen defendants. And I think it's why the decision came out the way that it did. So obviously the rule in Padilla is that defense counsel must inform the client whether or not their plea carries a risk of deportation. So that's the rule in Padilla. And that's the new obligation on defense attorneys. But one thing that I think a lot of people forget or don't know about Padilla is that although the burden is placed on the defense attorney to advise the client, and as part of their Sixth Amendment obligations, the decision does talk about the role of the state and the role of the prosecutor. And so this quote from Padilla, I think, is really valuable for defense attorneys to have on hand, because I know, at least in my personal experience, frequently I have heard, less so now that I've been doing this work a while, and hopefully in Dallas, I think the conversation has gotten better, but I know it's not the same everywhere, that sometimes prosecutors will say they can't consider immigration consequences. And that is just not true. That's not the law, right? In any county where they tell you that they have a policy that they cannot consider immigration consequences, I can help you write something up to educate them on what the law is on this, because the system in Padilla really requires that at least the prosecutor considers it. Now, that doesn't mean the prosecutor needs to give you what you ask for, right? I mean, the prosecutor is, in theory, weighing a whole bunch of factors when they decide how they want to come to an agreement with defense counsel. But immigration does need to play a part of that. And so if you see this quote here, this is the one that I always show prosecutors, because that negotiation relating to trying to mitigate immigration consequences, or at least considering the impact in immigration, is an essential part of Padilla. And really the whole Padilla system doesn't work if you can't negotiate with trying to mitigate immigration consequences or considering immigration consequences. And also, I really think the Padilla decision obligates judges because the whole way that this works is if defense counsel has an opportunity to negotiate and advise. So if defense counsel is being rushed through pleas, not given the opportunity to speak to an expert, do things like that, they can't comply with Padilla. And later on, Julie's going to talk more about judicial admonishments and things like that. But I think Padilla itself really does obligate the judges to give defense counsel space and resources to comply with Padilla. So like I said, it was a huge bomb dropped in the lap of defense attorneys, but at the same time, it truthfully should be altering things for everybody and should be altering the landscape for prosecutors and judges as well. So, and this is one thing that I always say, and Julie's going to talk about it more, but you know, I think a lot of defense attorneys are nervous to bring the problem to the judge if they don't have the support they need for getting advice. And I think judges need to be aware that defense counsel needs these resources and needs the support. And so this is a conversation without discussing your client's individual immigration status, the need to consult an expert, the need for time to do things like that. It's really important that defense counsel are vocal and advocate when they need those things, because obviously it can lead to them having consequences in the future for their license if they're non-compliant. But they need to sort of bring the problem to everybody. It's not just defense counsel's problem. Okay. So there's been a lot of case law since Padilla, and we know a lot more about the contours of what's required, and we're going to talk more about that later. But one case that I wanted to highlight is relatively recent, and it's from the Supreme Court. And that's J. Lee versus US. And I'll tell you, when they granted certiorari on this case, I was very nervous because Mr. Lee, the facts on this case are pretty bad. Mr. Lee, there was a tremendous amount of evidence of Mr. Lee's guilt, right? And when he was arrested, I mean, they had him good on all these charges. But Mr. Lee from the beginning was really clear that the thing he was the most concerned about was deportation. Like his number one concern, he'd been in the US his whole life, and he didn't want to be deported. There was no debate in the record that Mr. Lee's counsel misadvised him. His counsel said, don't worry about it, you can't be deported, and he was wrong. But the bigger debate was the second prong of Strickland. Could he be, was there prejudice based on him being given this incorrect advice? And one thing that I always want to highlight, and I'm sure y'all already know this, but the standard for prejudice about going for folks that plea is really, would they have gone to trial? Not would they have won at trial, but would they have gone to trial? And the reason that distinction is important is it's really focusing on the defendant's mentality and what the defendant would have done. So obviously evidence of guilt is a factor in that consideration, right? Not a lot of people want to go to trial if they know they're going to lose. But because Mr. Lee was so clear that immigration was what he was concerned about, the court found that he showed prejudice, that if that is what you were the most concerned about, you may take a Hail Mary trial and just go for it. I think previously a lot of people had lost Padilla claims under the second prong of Strickland, the prejudice prong. But I think you're going to see now, after Lee, a lot more people are going to be successful because it's sort of a shift in mindset about what the prejudice prong is all about. Okay, so that's Lee. So what does Padilla require? Padilla requires specific advice, specific to your client about what the immigration outcomes are going to be. And I think this is an interesting case if you want to read Ex parte Torres. This was an attorney had a writ filed against them for not advising their client sufficiently. And basically the attorney told the client, you should consult an immigration attorney. Immigration stuff could be bad. You're going to have to deal with immigration later. You should call an advocate. You should call an advocate. And I'll tell you, I speak to defense attorneys all the time that think that this is compliant with Padilla, but it's not. I always say, in the same way that you wouldn't require your client to write their own motion to suppress or do their own discovery, you can't require the client to do your job under Padilla. You really need to be the one to give advice to your client. Now, I do say this, if your client already has an immigration attorney that they're working with, that's fine, but then you need to call that immigration attorney and you need to understand exactly what the consequences of these charges are so that you're part of that conversation. Farming out the Padilla work is going to put you at risk for being found ineffective. Yeah, and so sometimes you'll see, and there's other case law that talks about advising clients if they're going to lose valid immigration status because of a criminal charge. So basically, the advice needs to be specific. One thing that I also see that is incorrect a lot is that I hear attorneys telling their clients they want to be sort of overly advising, so they tell every single client that they're going to be deported. So, right, you don't want to under-advise, which is what this guy did. He said, maybe something bad will happen with immigration when there was very clear, specific, more serious consequences than what he said. But you also don't want to tell everyone they're going to be deported if that's not true. You don't want to give anybody incorrect legal advice, right? There are certain criminal convictions that don't have immigration consequences, and you're going to need to be able to tell your client that. So there's sort of, you don't want to over-advise, you don't want to under-advise, you need to give specific and accurate advice. And so this is the scary slide, right? I'm saying all these things now, and you're thinking, how can I possibly do this? Well, when we get over to Julie's part, she's going to talk about how you can get a Padilla resource. And so don't be frightened. I mean, I'm trying to frighten you a little bit, but it's also, you're going to have, we're going to talk about the resources available to you in the second half of the presentation. Okay. So, right. So now we understand our obligations under Padilla, but what does that mean in this chaos of a pandemic? Well, first thing, your constitutional obligations to your clients don't disappear. Just because we're in a pandemic. So now we know what our obligations are, but I'm going to talk a little bit about how we want to try to comply with Padilla when we are not physically with our clients. So in Dallas County, I always do written advisals for our clients. Actually, really the way I do them is I write the advisal for the attorney that's directly representing the client, and then the attorney goes through the written advisal with the client, and we used to give the client copies of the advisal. So first thing, I want to make a little pitch about why when you work with a Padilla resource, it's great if that resource will give you something in writing, particularly during a pandemic. So I'm sure all of you guys know that video conferencing your clients in the jail is a bit of a nightmare right now. It's super echoey. It can be really difficult to hear. So I think having something in writing that at some point you can share with a client is really helpful. Some people in my office have been able to share their computer screen while they video conference so they can go through the advisal visually with the client while they're on the phone. That's amazing. That's probably the best way to do it because, again, like I said, there's so many issues with video conferencing. I also think if your client is comfortable and they have family members or friends who are helping them on the immigration end, it's really helpful if you can also send the advisal to them with the client's permission. And that way they can also get a copy of it. And if you know they're going to be in the jail, then you can mail them a copy of it. But I think putting it in writing helps avoid confusion. Already the immigration, whatever Padilla resource you're using is probably working remotely too. So it doesn't seem to me a great burden for them to do something in writing since they're going to be working remotely also. And again, this game of telephone, better to have something in writing when you can't discuss it in person. Obviously, something in writing is great record keeping for you too, right? If people go back and start challenging these pandemic pleas, you're going to want to have something solid and written about Padilla in your file. And I think it can help negotiations. You know, you have to be very careful how you share information about your client's immigration status with the DA. But for example, if you get permission from your client and like the client already has an ICE detainer, so it's not a shock to the DA that your client's a non-citizen, there may be valuable information that you do want to share, that you may be able to want to pull a citation and say, look, my client is charged with A and B. A is very bad for immigration. Here's the case law because I was given it by my Padilla resource, and B is better, and here's the case law. And that may give the DA cover to give you what you want. And so I think there's a lot of benefits to having it in writing, even if you can't physically give a client a copy of it right now. So I think, so basically how we're doing it in our office, and this is similar to what Julie's going to explain, is that we have an online form that the attorneys fill out, or a paper form, and they scan it to me. And then I write a legal memo, and then I send it back to the defense attorney. And then they share it with their client, like I said, either just verbally, but they have a written copy in their file. They share it on the screen. They mail a copy to the client. But that's how we've been doing it. And so the last thing I wanted to say about that is just that but as great as it is to have something in writing, I would not file that in the court record. That is confidential information between you and your client. Some of it is very sensitive. And so I think it's great to have something in writing in your file. And if you're very nervous about the client filing a writ and it's already out in the open that the client is a non-citizen, like they already have an ICE hold and things like that, I would just say, Your Honor, when the judge says, have you talked about immigration? Whatever immigration question the judge asks, you can just say, I've discussed it with my client and we have a written memorandum in the file, and nothing else, right? Because you don't want to disclose anything about their immigration status. You don't want them to admit anything on the court record. So you can just say to the judge, I've discussed it with my client. We have a written memorandum in the file. And then that way you have something in the record that shows that you did your job, but you don't disclose confidential information. Okay. So, okay, yeah. So what happens to your client? So you've done your plea and the person has an ICE hold, you've advised them, they understand, and let's say they want to plea, you plea, let's say it's a misdemeanor and their time served. What happens next? Well, they'll go to ICE custody. So the ICE detainer means that the person is usually picked up within 48 hours of their plea. The same thing holds true if in the end your client decides that they don't want to plead and they want to bond out on the criminal side. They're not going to physically get out because of the detainer, but they will go to ICE. So the ICE detainer activates the moment that the person is released from criminal custody, be that on a PR bond, a regular bond, or because they've completed their sentence, right? So they go to the ICE processing center, then they go to ICE detention. And many of our clients, those of us that work with low-income clients, the client will not have counsel at ICE, so you're probably the last attorney they're going to speak to. So what I do like to do, if you have access to get documents to your client, like if you have time to mail them things, there's an organization called the Florence Immigration and Refugee Project, FIRRP.org, and they have really great pro se materials for defendants. And so I recommend, if you want to give them, they have a good pro se bond guide for ICE bonds, and some other relief guides. So it can be really helpful. But in any case, you'll be done with them. They'll head over to ICE. So what's happening at ICE and with the coronavirus? Things are not great at ICE right now. They've had outbreaks at various detention centers. Prairie Land is the one closest to Dallas, has a big outbreak. Yeah, these are really crazy times there too. So, you know, I do think that your clients need to understand, if they're like itching to get straight to ICE because they think it's going to be better, I think they need to have a more realistic understanding that ICE is going to be equally problematic to being detained on the criminal side. That doesn't mean that they shouldn't go over there and try to get a bond there, but I just, you know, they're probably not going to have access to the information on what's happening right now at ICE, and right now it's not great over there either. So the sort of last thing that I'd like to mention is, you know, once they get over to ICE, they are technically, some of them will be eligible for bond at ICE. And some people are not eligible for bond based on certain criminal offenses. And if you want to know if your client's going to be eligible for bond, you could look at the immigration statute, which is Immigration and Nationality Act 236C, will show all the people who are not bond eligible. Everyone who's not under 236C can seek a bond, and they get 2 shots at a bond. They get a shot at, when they go to ICE, they can ask the ICE officer for a bond, or they get a shot, if they don't get a good bond from the ICE officer, they can ask the immigration judge for a bond. The immigration judge is looking at 2 things. Are they going to appear in court? You know, are they a flight risk? And are they a danger to the community? How could you help your client in this situation? Well, if you think the case is going to resolve favorably and you've set up for trial, you could send them with a letter, because that might make them think, oh, this person's going to show up at court. They're already fighting their other case. They've got relief in immigration court. But I also think the coronavirus really does push, we should be advocating that our clients highlight the risks of being in ICE detention too, right? If they're not bond eligible, they can seek something called parole from ICE, particularly if they have health issues. So you can sort of help them flag that to ICE, because, you know, clients don't know what they need to tell ICE that's important. If your client has a health condition, send them over to ICE with documents relating to their health condition, right? And some countries aren't taking anyone back right now. And so ICE is holding them for now, but if your client is from Honduras, Guatemala, as far as I know, neither of, and I don't think El Salvador is taking anyone right now, but definitely not Honduras and Guatemala, they should be saying, look, I'm at risk. You're not going to be able to deport me right away. Please release me on parole or bond. So, you know, again, that's not exactly your job, right? The job is to advise them before the plea, but I think a great thing that we can do, since we will probably be the last lawyer your client ever sees, is to at least give them some of the information about what a bond looks like and what's required. Yeah, I think that was the end of the things that I wanted to say, but I'll be available at the end for questions as well. Do I have another slide? I don't think so. Yes. Okay, thank you.
Okay. I think you can hear me because I'm hearing myself in Jordan's. There we go. From Jordan's computer. Okay, thanks, Jordan. That was great. I wanted to add just a quick statistic about Jordan's important point that perhaps some of the rationale behind the Padilla decision is that defense counsel is going to be the last person standing. And to Jordan's point about the lack of access to counsel in immigration court, you know, it's 14% nationwide of immigrants who are detained in ICE custody have a lawyer. And that was before coronavirus. And so now when you think also, as Jordan mentioned, about lawyers who may be reducing or changing the caseloads that they take in response to coronavirus and minimizing their own risks, you know, that 14% is likely to go down. And a reason that number is so low, there are many reasons, but you know, these detention facilities, as many of you know, where your clients are transferred are typically fairly far away from major metropolitan areas, and so they can be hard for lawyers to get to. It takes a lot of resources to represent folks in ICE custody well. And then I would also highlight that only for those of you who take appointed cases on the criminal side, only 2% of immigrants in ICE detention have a free pro bono lawyer, right? So there's no right to counsel in immigration court and immigration custody. So that number, of all of the folks that you might represent on an appointed basis, because of their indigence, only around 2% of those folks will similarly have a free legal resource on the immigration side. So I like to highlight that as well to sort of reinforce Jordan's point that you on the criminal defense side are often going to be the last attorney that your client sees, and you're sort of the last option for them to safeguard any options that they might have. Okay, so moving forward, if you were frightened at all by Jordan's presentation about the high burden that the Padilla decision imposes on defense counsel, in this piece, we're going to talk about a resource that's available to, right now it is available to folks who are criminal defense attorneys who take appointed cases or work in a public defender office within the 3rd Administrative Judicial Region. So it's all the counties you see there in the pink block. So all the counties in the 3rd AJR except for Travis County, which has its own Padilla resource through the Capital Area Private Defender Service. I will get to what if I'm not in the 3rd Administrative Judicial Region, and what about retained cases. We will talk about that as well. But I want to walk you through what this resource is. You know, like I said, it's available in the 3rd. The hope is that it could eventually be available statewide. So even if you're not in the 3rd, I hope you'll find this piece useful in case we're able to come to your jurisdiction. So myPadilla, it's a nonprofit service web platform where you, as criminal defense lawyer, are able to access a Padilla resource. So like Jordan is to the Dallas County Public Defender Office, if you are a solo practitioner or in a small firm, or even at a small public defender office like Far West Texas, for example, who does not have an in-house Padilla resource, this could be your option for obtaining written Padilla advice for your cases. So I'm just going to walk you through, since I can't do exactly a live sort of walkthrough of the platform. These are screenshots. So your first step, if you want to utilize the platform to meet your Padilla obligations, you would simply go online to the website mypadilla.com and create an account, which is basically you just tell me who you are and where you practice. I then review the accounts to make sure you're a real live human. I approve your account for use. You'll get an email that you've been approved and that you can use it. Then you just log in with whatever password you set. And then when you log in, you'll see this as an example. So it sort of looks like any other case management system that you might use, in that it has this sort of case tracking up top where you can see which cases have you submitted, when did you submit them, when did you ask to hear back by, and what's the status. Down below here at the bottom under how it works, you'll see sort of what is all the information that you will need to put into the system for us to be able to respond and provide you advice. we'll talk a little bit in the next section about why we need that kind of information. Okay, so the first time you log in, if you don't have any cases, you haven't submitted any cases, you'll just click this green button in the top right that says Start New Intake, and that will take you roughly to here, which is the intake form split into 3 sections. Those sections correspond to the information that we need to be able to respond accurately and specifically and give you tailored advice for your client. So that those buckets of information are, what are the current charges? Do you have a plea offer? You don't have to wait until you have a plea offer. You can submit it as early as you know what the charge is. I've even had some folks submit, pre-indictment. They really want to get ahead of the game. The second bucket is criminal history. We'll talk a little bit about why it's important for us in a lot of cases to know what your client's prior criminal history is, because sometimes it's the prior criminal history plus the current that equals the immigration consequence. And then the third bucket of information is biographical info about your client. So what's their current immigration status? How long have they been a legal permanent resident? If they're a legal permanent resident, when does their DACA expire if they have DACA? And then a sort of screening to see what other forms of relief they might be eligible, right? So you might be representing a person who's undocumented but married to a citizen, and they might have an application to adjust status pending based on that relationship. So those are all questions that we would get to in that third section. I also want to mention for section 1 about the current charges. It is helpful, even if you don't have a plea, it's helpful. Sometimes folks like to submit these before they get a plea so that they can hear from us, from me, sort of what should I try to get? And then some folks like to wait till they have a plea offer on the table to know what the specific consequences are. You can do either way. Just in general, it's helpful anytime you work with an immigration attorney who doesn't have an extensive history of practicing criminal law themselves. It is helpful for you as a criminal defense lawyer to sort of flag, this is what I think might be in my jurisdiction on the table in this case. And that is because immigration lawyers don't always know, unless they've been doing this for a long time, they won't always know, like, oh, this is a common alternative plea in this situation, given this client's sort of history. So that's something I wanted to flag there. So it's essentially an online questionnaire asking you questions about all of those buckets of information that I mentioned. My screen is a little bit obscured by the video window, but you should see a little next to, is there an ICE hold detainer, little question mark in a gray circle. Those are throughout the platform. If there are immigration terms and you are not super familiar with immigration law and you don't know what these terms mean, though if you click those little question marks, they will explain the terms for you. So this is essentially what the questionnaire looks like. At the end, we ask you what your client's goals are, and that can occasionally impact the recommendation that we make. So you filled out the information. If you just wanted to start filling it out and you don't have all the answers yet, so say you are in your office and you want to fill out the information about the pending charges, but you haven't interviewed the client yet, you can just you can save it and come back to it later. It'll show up in your dashboard as a draft. Once you are done and you submit it, it will show up as in review, and that means that we are working on it. And then when we essentially, like Jordan does, write a written advisal, a memo, a legal memo to you as the client's attorney, we upload it into the system, and then you will get a notification that it is there, and it'll show up in your dashboard as complete. And then on the far right side where it says view advice, you just click there to open up the memo. It doesn't have to stop there either. I certainly have defense attorneys who want to follow up. If I've made a recommendation, but they weren't able to get exactly that recommendation, but something slightly different, they'll follow up. We can do all that by email. My email is at the end of this presentation, but it's also julie@mypadilla.com. And also related to coronavirus, I wanted to highlight too that one strategic question that you are welcome to also reach out about is what Jordan was talking about, whether your client should bond out on the criminal side if they have an ICE hold and are just going to go into ICE detention. And so analyzing whether they're going to be subject to mandatory detention if they enter a plea on the pending criminal case, whether they will be eligible for bond on the immigration side. We can help you think through those things. If, anytime, but particularly right now, if you're in a jurisdiction that is trying to move people out of criminal custody more rapidly than they were before, that we can help you think through whether whether bonding out on the criminal side and going into ICE detention is going to be good or bad for your client. So this, I should mention, myPadilla is available in the 3rd Administrative Judicial Region because of generous support from the TIDC through our partner Hayes County in the 3rd. And so this is a pilot program that started in late fall and goes for a year. And this is some of the feedback that we have gotten so far from your colleagues who have, I think, just generally felt a sense of relief that now they have a resource to navigate this rather complicated area of law. So if you are so inclined, we hope that you will go to the website mypadilla.com and think about using us as a resource. I told you I'd mention if you are not in the 3rd Administrative Judicial Region and you take appointed cases, you're welcome to reach out to me by email to talk about your specific needs. I do work with attorneys on appointed cases outside of the 3rd who need a resource. A lot of times they'll file, as Jordan was talking about, they'll file a motion for appointment of an expert, and then they could use myPadilla or they could use any other immigration attorney. I think that's really important, as Jordan mentioned too, to really educate judges about the need for this kind of resource. And so I can work with you there for retained cases anywhere in the state. You're welcome to use the myPadilla, the platform, for a fee. Okay. So that's an overview of essentially how to use the website. And, as Jordan mentioned, we do, similar to what she does, we write back in writing for all of the reasons that Jordan mentioned. We think it's very important to document in writing the advice. A few other, I think, advantages to using the platform. If you go through the questionnaire, we're able to really minimize the back and forth. If you have ever just called an immigration attorney and asked for advice on the fly, a good immigration attorney will often have follow-up questions because it is hard to, well, for reasons that we'll talk about, the advice will vary depending on the client's particular circumstances, prior criminal history, etc. So the platform will prompt you to input the information that we need to really minimize that back and forth. I'm going to pause. Whatever the allergen is, it's happening. It's also easy for you to keep track. You won't have to think like, oh, did I already contact an immigration attorney about XYZ case? It'll be there in a sort of case tracking system for you. Also, if you have ever called an immigration attorney and left a message and not heard back, that will not happen with this platform. If you sign up and submit a request, that we will answer if you're within our parameters, which we'll talk about with you before you submit any cases. So I hope that it eases a little bit of the burden in that that somebody who knows a lot about these topics will respond and in writing. We can also do, as Jordan mentioned, the memo that we write back to you is not one that we would recommend that you share with the prosecutor or file in court. But if you need something, and I have this, maybe 10% of the time, and a defense attorney will say, can you write me something else to give to the prosecutor? And I'm happy to do that as well. And we just put in a little bit less information, sensitive information perhaps about the client's status or family or whatever the sensitive information might be, and just we can focus on whatever you think is most important for negotiating with that prosecutor. Okay, I think that was everything I wanted to say here. And now we're going to move into talking about why we think it's so important to use a Padilla resource, whether that's myPadilla if it's available to you, or whether that's a person like Jordan, an in-house Padilla resource, or whether that's an immigration attorney of your choosing. And so we're going to get a little bit into the weeds, not too deeply, but really the overall point that we're trying to make with this section of the presentation is that immigration law is complicated. It is complex, it's nuanced, the consequences are going to be specific to your client, and different clients will be affected differently by the same charge. And so we would encourage you to use a resource so that you don't have to memorize any of the rules or case law that we're about to go over. Okay, so as we sort of mentioned already, the 3 buckets of information that an immigration attorney needs in order to be able to advise you about the immigration consequences for your client, we're going to need to know current charges, immigration status and history, and prior criminal history. And I sort of analogize it to, if you called an immigration attorney and said, I'm representing a guy charged with assault, is he going to get deported? That is sort of akin to like calling a CPA and saying, I made $100,000 last year, how much do I owe in taxes? Right, so there's a lot more follow-up, there's a lot more nuance that's going to determine how much you owe in taxes, and there's a lot more nuance that's going to go into determining what the immigration consequence is going to be for a person charged with assault, for example. So it's really at the middle of those 3 circles where the specific tailored advice is possible. I want to highlight too that the Court of Criminal Appeals has recognized that this is a heavy burden for criminal lawyers who don't specialize in immigration law. And so they have written in a decision that they do anticipate that you all will need to reach out to immigration law counterparts when representing folks who are not citizens of the US. Okay, so now this is going to be just a real quick taste of some updates in the intersection of immigration and criminal law, the intersection of the Texas Penal Code with the INA, the Immigration and Nationality Act, how federal courts are interpreting it, how the agencies are interpreting it, interpreting that intersection. And again, I would say if you are able to use a Padilla resource, you do not need to memorize these rules. This is just a sort of to give you some flavor for how the rules, how the interpretation is updated, and the fact that this is not a static area of law, right? So we can't just hand you a chart about what the immigration consequences are, because tomorrow a decision could come down that might change those consequences. So that's why we think it's really important to consult a live Padilla resource contemporaneously as you're representing somebody. So one case to highlight that point is US versus Reyes-Contreras. That was late 2018, I think November. And it was a really mammoth, very long decision from the Fifth Circuit in which they totally overhauled the way that they interpret 18 USC 16A, which is part of the crime of violence definition. And why that's important is because a crime of violence with a term of imprisonment of 1 year or more is an aggravated felony for immigration purposes, if you've heard any of those terms. It's also important because a crime of violence, regardless of the sentence, if committed against a person protected under domestic violence laws, is a deportable crime of domestic violence. And so essentially what happened is, 18 USC 16 is what defines crime of violence. The Supreme Court had invalidated the second subsection, 18 USC 16B, as void for vagueness in Sessions versus DiMaia. And so then sometime later, the Fifth Circuit revisits the first subsection, subsection A, and just really expands the types of crimes that can qualify as crimes of violence, that do qualify as crimes of violence under that definition. And so, the definition under 16A is a crime that has as an element the use, attempted use, or threatened use of force. And so the court in Reyes-Contreras looked at, well, what does force mean? And decided that whereas previously indirect force wasn't sufficient, now it is going to be sufficient. And a few other things. The main takeaway really for you is about assault. So previously assault wasn't a crime of violence because of some of the reasons described in the decision, and now it will be. So that's an important takeaway. Herald is another recent update on the intersection of the Texas Penal Code with the INA. And so, Herald had a couple of en banc decisions, a couple of intervening Supreme Court decisions. It was a very, I think as the Fifth Circuit itself said, a sort of winding path. But the upshot was, the courts were trying to figure out, is Texas burglary federal burglary or generic burglary as defined for immigration purposes. This matters because burglary with the term of imprisonment, federal burglary, generic burglary with the term of imprisonment of a year or more is an aggravated felony. And so, there were a lot of questions that the courts were dealing with. It was, one, is the Texas statute multiple crimes or just one crime? And they ultimately decided that it's just one crime, that the jury doesn't have to decide whether you enter with intent or whether you enter and then later form an intent. That was Herald 1, and that survived some of the later changes to the law. And then they were also, just deciding whether trespass with later commission of a crime meets the federal definition, which is, the A3 subsection under the Texas Penal Code. And they decided in Herald 2, based on some of the intervening Supreme Court cases, Quarles and Stilt, that it does meet the definition. So now Texas burglary categorically matches the definition of federal burglary, again, absent any future litigation. And Jordan has some fun arguments that you can preserve about why that shouldn't be the case. But for now, that is the law. Castillo-Perez is a very important one that came out in 2019, I think October. This was the decision from the AG himself, so certified to the AG. The AG certified the decision to himself to render. And this was about the consequences of a subsequent DWI conviction. And in the decision, the AG decided that if a person has 2 or more DWI convictions within a certain period of time, then they will be presumptively ineligible to establish good moral character. And so if you're saying to yourself right now, well, how much time? And well, who needs to establish good moral character at all? Who does that matter for? Those are great questions. The period of time, for which the person needs to establish good moral character depends on what they're applying for. So it can be 1 year, it can be 3 years, it can be 5 years, it can be 10 years. And not everybody needs to establish good moral character. It's going to depend on what your client might be eligible for and seeking, but it's relevant to voluntary departure, cancellation of removal, naturalization, which is the process of becoming a citizen for somebody who's already a legal permanent resident. And so, that's an example. I think Castillo-Perez is an example of if you had previously memorized a rule that simple DWIs are generally fine, except maybe for people with DACA, and except insofar as it's going to make somebody less likely to get a discretionary bond. That rule, if you had memorized that rule would now not be accurate. And so that's, Reyes, Contreras, Herald, Castillo-Perez, all just examples of why the law does change and evolve. And there are, if you're saying to yourself, I don't want to keep up with all of this nuance and minutia that Julie is talking about, that is exactly why we think it's wise to sort of offload that responsibility for keeping up with immigration updates to somebody who wants to do it and is able to really stay up to date. I'm gonna skip these and come back just for time, but I would highlight, Nielsen versus Spreap was a Supreme Court decision about mandatory detention, and the question there was essentially whether a person would be subject to mandatory detention for a criminal offense only if ICE picked them up right after the conclusion of that criminal offense, or if ICE picked them up 20 years later. And as you might guess, the answer was if ICE picks them up 20 years later, they can still be subject to mandatory detention from an offense for which they had been released decades before. And so that's relevant to you because if you are representing somebody who's out of custody and does not have an ICE hold, it is still important to advise them about how taking a plea in that case would affect their eligibility for bond from immigration detention later because of this Nielsen case. Mohammed we'll talk about later. And then just want to highlight that there are a couple of decisions pending at the Supreme Court this term that will also affect how we advise folks. So one is the pending DACA case. Right now, folks who have DACA or previously had DACA can renew it. People who've never had it before are not able to apply for the first time. But the future of that program is the subject of multiple cases pending at the Supreme Court. Barton versus Barr is a case that will affect whether certain offenses are going to affect somebody's eligibility for cancellation of removal. And so it's super hyper technical. You know, can you be rendered inadmissible by an offense if you are not subject to the inadmissibility grounds, is essentially what it boils down to. And if that sounds very like, if a tree falls in a forest, does anybody hear it? No. Yeah, is that how that goes? Anyway, that's essentially what that case is going to be about, but it will affect advice going forward. Oh, this is the last page of Reyes-Contreras, just to show you that the Supreme Court was really, in their words, scraping some barnacles from the case law ship, I think is what they said. So this is a list of all the cases that were overruled by Reyes-Contreras. So I'm gonna wrap up so we can do questions, but I also wanna highlight there's this pending, you know, it's not just federal courts interpreting the intersection of the Texas Penal Code and the INA, it's also agencies changing policies. So there is a pending notice of proposed rulemaking issued by DHS and DOJ jointly that would make ineligible for asylum folks convicted of all these offenses on the right. So that's the type of thing where if I'm advising you, hey Jeff, if I'm advising you, you know, that this offense doesn't make your client ineligible for asylum today, but it might in the future if this new rule is enacted. Let me just highlight this because Jordan touched on it as well. You know, if you use myPadilla, when we respond to you, we will respond with, you know, not just whether this makes your client subject to removal, but also we will advise you about the variety of immigration consequences that a person can experience because of a criminal offense. And those are varied. You know, it's not just, are they going to be removable? It is, will they be ineligible for relief in immigration court? Will they be ineligible for affirmative status? Will they be subject to mandatory detention? Ineligible to return from abroad? I mean, that's a really important one for legal permanent residents who, you know, if you can avoid a legal permanent resident being deportable, that's not the end of the potential immigration consequences. Because if they leave and go home to visit their family and try to come back, they will be subject to a different set of rules, which are the inadmissibility rules. And so we will also advise you about that. Like, yes, your client could take this plea, it won't make him deportable, but he should know that he should not leave or he will have issues coming back, for example. And that case on the right, Aguilar, is a case from 2017 where the state court agreed that it's not just, Padilla is not just about legal permanent residents losing green cards. It also extends to, in that case, it was a person with TPS, temporary protected status, losing that immigration status and then being subject to removal on that basis. I'll stop there. We have more to cover, but maybe we'll get to it in the questions.
Great. Thanks, Julie. Thanks, Jordan. You packed in a lot into an hour. That's impressive. We have over 300 people on the line and we have dozens of questions, and we'll get to as many questions as we possibly can. Just to start with, several folks asked about myPadilla and the link for it. We put that in the chat box, so you should have a link there. Julie's email address is also in the chat box. And then Jordan, one of the questions actually was more of a statement that you have a great resource that you published on immigration consequences with Texas Appleseed. And people were wondering if there's a way to get a hold of that.
Yeah, absolutely. If you go to Immigration Consequences Texas, or TX, immigrationconsequencestx.org, it'll take you to the Appleseed website and you can sign up. We're trying really hard to keep this resource within the defense community. So it's going to ask you what you do in your email, and then you're going to get like vetted just to check that you're not like an ICE prosecutor. And then it'll release the resource to you. And yeah, and it was with the help of TIDC. So thank you guys for making that manual possible. Right now, there aren't a ton of statutes on there. And it's really, I think, a resource that you'd want to use in conjunction with an immigration attorney, but there's some good information on there. Julie's been helping me with it too, and we're hoping to get more stuff up now. So it's sort of a rolling, updated, living thing on the internet. But there's a lot of good information on there about your obligations under Padilla too.
Right. And I think we just put a link to that in the Q&A function. So if y'all didn't catch the link, it is in the chat function, so you can find it there. So thanks, Jordan. That's great. I mean, man, between that and myPadilla, I mean, we've got a lot of great resources in Texas, which is pretty cool. Not every state can say that. Can juvenile adjudication have immigration consequences? That's a question that came up several times.
You want to take this?
Yeah, so juvenile adjudications are not convictions for immigration purposes, but there are certain immigration consequences that are triggered by commission of an offense and not conviction. And so like drug trafficking, prostitution, things like that. So it'll depend on what the charge is, but yeah, it's not juvenile adjudications are not convictions for immigration purposes.
And the only other thing that I would say about that is that as much as juvenile convictions are confidential, if you're working with juveniles, you want to tell them to be very careful before they turn over anything to ICE, even if ICE asks for it. I think a lot of juveniles turned over things when DACA came out that they were not legally obligated to turn over. And in fact, some of them weren't even court released to be turned over. When I first moved to Texas, I called the juvenile court and I'm like, hey, are juveniles getting their records? And the woman I spoke to in the juvenile court was like, oh, when DACA came out, we had lines around the block of juveniles getting their records. And I was like, no. A lot of times the juvenile judge has to release them. And if the advocate explains to the judge, if you release this, it's bad for my client, then the judge might say no, and then the juvenile could go to immigration and say they won't release my records. So just I want to throw out the confidentiality issue because a lot of your clients may not know about it. And the best thing we can do is to keep the juvenile records completely out because they're not convictions.
Yeah, that's great. That's very helpful. Backing up a little bit to just a more kind of, I guess, a first question before you even dive into any of this. How do you find out what a client's immigration status is? A few folks had asked this question about, a lot of our clients don't actually know what their immigration status is. How do attorneys go about finding that out?
You want to start, Julie?
Sure. Yeah, so, the first question to always ask is, where were you born? And that's the question that we start with. And, from there, I find that clients who have a valid status right now often know what that valid status is. It gets a little trickier if they entered on a tourist visa and they're telling you they entered on a tourist visa that was valid for 10 years and it's 7 years into that time period. Tourist visas are not permission to be in the US for 10 years, even though there's a 10-year validity on them. And so I think it gets a little trickier in those circumstances. I always recommend asking clients for any documents they have from immigration, asking clients' families for any documents they have from immigration. If they have an A number, you can call the EOIR, which is the Immigration Court Hotline, to see if there's been any prior history there, if they've appeared in immigration court before or been ordered removed before. It does get very tricky if a client's telling you that they've had interaction with immigration authorities at the border. It gets very tricky to know whether that was, and if they went back to their home country after that, whether that was a voluntary return or an expedited removal situation at the border. So I don't have a great answer other than get as many documents as you can. And certainly if you end up using myPadilla, I have had, maybe in 1% of cases where the immigration history was so complicated, what the defense attorney was telling me was so complicated that I'll just get in touch with the client themselves and try to get to the bottom of it. So those are my tips.
Also, I think, there's no public database for immigration status, so you can never look it up. It's never going to be that simple. What I do at the beginning of my advisals is I summarize the referral and I summarize what the client told me, and then I write the advice. There's only so much you can do. So I think the reason that I summarize it at the beginning of the referrals, I want to cover the defense attorney. If later on it turns out the client was wrong, that's not the defense attorney's fault. It's not the defense attorney's obligation to do a huge amount of investigation. You just have to give advice as best you can based on what the client tells you, which is, again, this whole thing about in writing. That's the advantage of doing a referral sheet, right? Filling out a sheet and summarizing it in the memo is at the end. If a client comes back later and is like, oh, actually, I had DACA and I never told you. Well, that's not going to be the defense attorney's problem. That stinks for the client. But if you've asked them and they've told you what they've told you, that you're going to do the best you can to represent, give them advice based on the advice, the information they give you.
So it sounds like reaching out to a Padilla attorney, whether it's myPadilla or it's a Padilla attorney. A lot of the urban areas, Dallas, Travis, Fort Bend, Harris County have a full-time Padilla attorney. A lot of the rural areas don't. We're trying to address that in part through myPadilla, but it sounds like that's one of your first steps. I mean, if you really want to figure this out, reaching out to a Padilla attorney and talk to them.
Yeah, absolutely.
And then once you talk to that Padilla attorney and you get this written advisal, I mean, we had another good written advisal question, which was, how do you deal with it? All right, so you've got a written advisal in hand. I've got a client who, let's say, is illiterate, or a client who has problems with reading comprehension, or has mental health issues, or maybe there's even just a mail issue with the jail. They're not getting their mail timely. So what do you do if you're the defense attorney? You've got this great written advisal. As far as giving a copy of it to your client or explaining it to your client, what do you do?
Do you want me to take this one? Yeah, I mean, I think, look, you're gonna do the best you can do. I mean, it's true with all your plea paperwork, right? How do you talk about their appellate rights to them when they don't read well or they have diminished capacity? I don't think it's entirely different. I think you're gonna do the best you can to explain it as best you can, and then you're gonna mark up your file, right? You're gonna say, on this date, I went through the advisal. These are the things I highlighted. These are the questions they asked me. This is the way that I tried to explain it. I mean, I think in the end, you know, defense attorneys are in a really tough position. Obviously, if you don't think they're competent to understand the representation, you may want to phrase that with the court. But like day to day, you know, I think you're going to do the same way that you do it with the appellate rights and the same way you do it with their jury trial rights. You're going to explain it as best you can, and you're going to make notes in your file. I mean, that's my opinion. I don't know.
So it sounds like in part you need to tailor that to the client. It's going to depend on the client, and the advice is more follow whatever practice you're doing for anything else, plea paperwork or anything else, and that tailor to your client.
Yeah.
What about written advisals? Would you just had a question pop up about written advisals in other languages?
We do verbal translation. I don't do them written in another language. So the way that I format it is there's like a little header that I use on all of them explaining the immigration consequences of the charges. And then at the end, I have a little block at the bottom that says, this was translated for me verbally this day by this person, and they sign. I'm just not truthfully adept enough at writing in Spanish to write them in Spanish. I don't speak Mandarin. I don't speak enough languages to do them in the other languages. So that's the best way that we can do it, is the written document and then the verbal translation. But it would be great if we could have them in all languages. That would be ideal, but just not.
Yeah, and I'll say that it's a little different for folks who are in-house Padilla attorneys at public defender or MAC type office, public defender offices where the clients are also Jordan's clients, right? But if you're using a myPadilla or an outside immigration attorney, you know, they're not necessarily forming an attorney-client relationship with your underlying client. So how our program is set up is that you, defense attorney, we are in an attorney-client relationship, or essentially I'm your consulting counsel. And so the advice is given to you for you to then communicate to your client. It's also, you know, the format that I use is that it's similar to Jordan. You know, it's a legal memo where I'm going to tell you why I'm concluding the way that I am, right? So what is the case that I'm relying on to tell you that evading on foot is not a CIMT? So, you know, that's not the type of thing that you would necessarily hand over to your client for them to know. So I agree with Jordan that I think most folks, you know, the written memos for the attorney to then sort of verbally translate to the level and ability of the client.
So Julie and Jordan, we are at the top of the hour. We still have just about 300 people on the line though, so apparently people are liking what you have to say and want to stick around a little bit. Do you all have maybe another 10 minutes or so to stick around and answer a few more questions? We won't get to everything, but hopefully we get to as many as we can. You know, and actually somebody just wrote in the comments, by the way, that you all are so great, so knowledgeable, helpful, and smart. Thank you. So glad I'd share that.
That's really nice. Thank you.
You know, we had several people ask about sharing a written advisal. Is that, you know, one, would you all be willing to do that too? Is it helpful to defense attorneys to see a sample written advisal, or is there a danger there in that it's not really tailored to their client?
Yeah, I don't know that a sample gets you very much because it's so tailored to the client's circumstances. You know, what I would say, I think Jordan and I do a similar format, and other of the Padilla attorneys around Texas probably do a similar format, which is that we talk about all of the things in that last slide that I don't know if it's still visible or not. We talk about all of those things. So, you know, we talk about, one, what is the information you've given me that I'm basing this on about the client's immigration status, prior criminal history, and the current charge. Two, is the offer going to be a conviction for immigration purposes? So we didn't get to this, but as many of you probably already know, the definition of a conviction for immigration purposes is different than the definition of a conviction under state law. So deferred adjudications in Texas are convictions for immigration purposes. Some pretrial diversion and deferred prosecution type agreements will be convictions, depending on how they're structured, where the admission of guilt is held, and what role the judge has. The case to read on that is Matter of Muhammad from the BIA from 2017. And so then, recite what you told me. Is it a conviction for immigration purposes? How is it sort of classified under the immigration law? Is it a crime involving moral turpitude, or do we think it is aggravated felony, crime of domestic violence, firearms offense, etc.? Is it going to subject your client to loss of their current immigration status if they have an immigration status? If they don't, is it going to make them, or even if they do and they would lose it, or is it going to make them ineligible for relief from deportation or a potential future immigration status for a legal permanent resident, NATS, ability to return from abroad? So we just sort of go through the litany of consequences and make recommendations. I think it's important too to note that even though we've sort of talked about how difficult the burden is and how difficult immigration law, and you read the news and you see what's going on with immigration, there are safe pleas. Not every plea, even if it is a conviction for immigration purposes, is going to trigger consequences. And there are often tweaks that we can suggest that would make the plea safe for your client. So even though we've been hammering on about how complicated immigration law is, that's not to say that there are not opportunities to secure an immigration neutral plea for your client.
So we had several myPadilla specific questions for Julie. One is if you could mention again, what regions are actually covered by this right now? Two, does it apply to federal cases? And three, sorry, asking a compound question here. So what areas is it available in? Is it available for federal cases? And if you have a retained client, can they still use myPadilla and pay for it?
Yes, am I unmuted? It's available right now for free on appointed cases in the 3rd Administrative Judicial Region. So that's essentially all the counties in Central Texas besides Travis. So we can, I don't know, maybe we can put a link to the county list somewhere in the chat window. And then it is not available in federal cases right now. I'm wondering if that question came from Waco, because I've heard a lot recently of folks needing more of an immigration resource in Waco. My experience with federal cases is that usually the Federal Public Defender's Office is quite, if there is, I don't know what the status is in Waco, but Federal Public Defender offices are usually quite adept, and I think, provide companion resources to CJA attorneys. That maybe that's not the case in Waco, because I know I've gotten a lot of questions from there, but right now it's not available in federal cases. You can contact me to talk about that more if you'd like. And then the last question was, yes, retained cases anywhere, you can use it for a fee, which should be on the website, or I'll drop it in the chat. And it is, because we're a nonprofit service, the pricing of it is meant to be sort of middle of the range. So it's similar to what other immigration nonprofits charge for advisals, which is usually $500 per. That can vary a bit. So also I want to say, if you're outside of the 3rd, I think I saw this question somewhere. If you're outside of the 3rd and you're on an appointed case, and you're wanting to ask the judge to give you fees to pay an expert, whether that's myPadilla or somebody else, somebody asked, the fee there is $150 an hour, and it's usually 2 hours, so it's usually $300.
And Jordan, is there any law? We had this question come up a couple times. Is there any law that requires judges to appoint immigration attorneys upon defense counsel's request?
No, I don't think there's necessarily a law, but if they care at all about the integrity of their convictions, you built a beautiful record on appeal when you requested an immigration attorney and it was denied. And then if the client takes that up on appeal and that's all in the record, that's really bad. That's going to look bad on the judge, right? They need a knowing and voluntary plea, and the attorney told you, I need this resource, and they say no. I think it's a great appellate issue, and I think the judge is going to be aware of that. When they have a formal written, and that's the thing, you got to put that motion in writing and get a proper ruling on it so that they can use it at the appellate level. But I think when the judge is forced to put in writing a denial of that request, they know that they're queuing up an appellate issue. And just to sort of build on that, a lot of people tell me, I do trainings around the state, and they say, oh, our judges won't do it. And I said, well, how many of you have made a request in writing? And generally people, no one has. And so I think the defense bar has been shouldering the burden of Padilla for so long, and you've got to bring it into the judge's backyard and make it their problem. Because the good thing that happens is if enough people start doing that, then the judge is going to say, maybe we should get like a setup like Julie, or we should get someone like Jordan hired for our county. You know, either way, we need to address this more formally if it's coming up. But until we raise it, and until we start making the judges pay money and issue rulings and get overturned on this stuff, they're not going to change. And so it's time to bring the fight to them, you know?
And I understand you all have like a group of Padilla attorneys across the state within Texas that you're talking on a regular basis, right? And kind of sharing pointers and issues and that kind of stuff. That's really neat. You know, there was a related question to this, that what happens if you're in a jurisdiction where the standard line is, we don't consider immigration when we're working out plea deals. We don't look at that. What's your reaction to that? How do you handle that as a defense attorney?
I bring them Padilla. I mean, I bring Padilla down and I highlight it and I explain to them that's not a thing. Like the Supreme Court absolutely contemplates negotiation based on immigration consequences. So last time I checked, the Supreme Court, you know, their word is worth something. But I bring down the case law because I think sometimes it's genuinely an education issue. They don't know that the law says anything otherwise. There's a ton of great law review stuff about the obligation of prosecutors under Padilla. There's tons of materials. I teach crimmigration at a law school, and I do a whole section on prosecutors' obligations under Padilla. There's a ton of material out there. So I bring something physical down. And sometimes I think it's more even that the prosecutor needs cover if they're dealing with their supervisor. And if you can provide something in writing to them, I think they feel like I've got the cover to do the things that I need to do, and I can show the law, and it's not me being soft on immigrants.
Yeah, and just to add on to that, you know, what I hear sometimes is, well, if I tell the prosecutor out loud, you know, that my client can't take this plea because of immigration consequences, they don't believe me that is the consequence. And so that's where the sort of letter tailored to showing to the prosecutor could be helpful. You know, and I would also say that I leave it up, obviously, to the defense attorney as to whether they think it's a good idea to raise or not, but in terms of negotiating with the prosecutor. But it's also important to note that, you know, I think defense attorneys oftentimes, and maybe they've had experiences with immigration attorneys where the immigration attorney says, you have to get this dismissed. This is the only outcome that's acceptable. And, you know, yeah, sometimes that's true. But as I mentioned before, a lot of times there are other alternate pleas that can be arranged or tweaked to be immigration neutral. And so if you're just, you know, chatting with a prosecutor, they might be thinking that when you talk about immigration consequences, you're talking about necessarily dismissing it because of the immigration status of your client. And in reality, we're not necessarily talking about that. And sometimes the client can plead to a more serious offense that is immigration neutral than a lesser offense that is worse for their immigration status. And so that can sometimes be the unexpected result as well.
That's a really good point.
We're at about quarter past the hour, and amazingly, we still have 250 people on the line. So apparently, this is helpful. They've already gotten their CLE, so they should be good on that. But I think they like the Q&A. I think maybe we squeeze in one more question if you all are okay with that. And then after that, are you okay with people reaching out to you with other questions when it comes to Padilla? Excellent. Okay.
Yes, and I just want to highlight that Gretchen mentioned in the chat window that Barton v. Barr that I mentioned was decided today, so everybody can
oh my gosh,
go read that.
It was?
It's going to be exciting. Yep.
Apparently just decided this morning. Yeah, this is what we heard from a couple of attorneys today. So I will ask this last question, then you can go and read. Then you can go and read Barton versus Barr. So the last question: can pre-trial diversion or alternatives to incarceration have immigration consequences?
Yeah, so that's sure, but either way, that gets to what I was mentioning before about that Matter Muhammad case, BIA case from 2017. That was about a particular Texas pretrial diversion and concluded that one in that case did constitute a conviction for immigration purposes. So the definition of a conviction for immigration purposes is an admission of guilt or admission of sufficient facts sufficient to warrant a finding of guilt together with the judge ordering some restraint on liberty. And so in Muhammad itself, you know, the judge was like approving the pretrial diversion agreement ordering that the defendant participate in it. And then the BIA said, well, even if the judge sort of hadn't done that as a matter of law, the judge is the only person who could order the payment of fees to CSCD. And so that's a decision that I recommend to folks. That doesn't mean that all pretrial mechanisms are convictions, right? So it's going to come down to how specific is the admission. Normally, obviously, they're pretty specific, but how specific is the admission of guilt? Where is it held? Is it in the prosecutor's file, or is it filed in the court record? And then what's the judge's role? You know, is the judge just leaving the case open on the calendar, on the docket, for the client to complete terms agreed upon off the record between prosecutor and defendant? Or is the judge approving, you know, yes, you will not commit other crimes. Yes, you will report every month, whatever. So it gets pretty nuanced. And then, you know, it also depends a little bit on who's going to have the burden of proof on the immigration side, which I'm actually we'll not get into that because it's a little weeds, but that can affect to how safe a pretrial diversion agreement is. Is the government going to have to prove that your client was convicted for immigration purposes, or are you going to have to prove that you were not convicted for immigration purposes? I also, while we're talking about this, just want to mention, because we didn't get to the sentencing slide, that the definition of a term of imprisonment or a sentence for immigration purposes includes any time that was suspended or probated. So if you've got 3 years suspended for 10, that is a 3-year sentence for immigration purposes. And I do want to make sure that folks are aware of that.
And also that safe P is a term of prison for immigration purposes. It's a term of confinement, safe P, which is through this case, Cabillo Garcia versus Sessions. And that's a real bummer, because usually those safe P sentences are like up to a year. And so you've got to be really careful. If the term of probation includes safe P, that's going to be considered a period of confinement. But again, if you use your Padilla resource, they'd be able to tell that to you.
Gotcha. Well, man, we have so many more questions. I know we're out of time. We're actually well past time, but thank you so much. I mean, Julie and Jordan, this was so helpful, as you can tell from all the questions and comments. We just included in the chat box a link to both Barton v. Barr and a SCOTUS blog description of the case and kind of analysis of the case. So that's in your chat box. Thank you again. And folks, we'll leave up just the chat box for another minute if you want to access any of the links to myPadilla or to Barton v. Barr. And then we'll have, I think, Julie, we already have your email address. Jordan, is it okay to include your email in there? Okay. So we'll include both of your email addresses in the chat box. Thank you all again. And thank you so many. I mean, gosh, we had over 300 people attend today. Thanks for joining us. And we'll see you all next week for, we'll have Kathleen Casey Gomez and Casey Kennedy talking about online courts 1 month in to see where we're at.
Awesome. Thank you, Jeff.
All right.
Thanks, everybody.
Thank you all. Appreciate it.
Bye.